because an arbitral tribunal is not in a position to effectively manage the case by suspension supervision. The respondent used Article 6 of ILO recommendations on these standards address judicata and arbitration. But in this Article 6 there are three reasons why arbitral tribunal should suspend the provision, the arbitration provision. First reason is the parallel proceedings are between the same parties. Second reason is they are relating to the same subject matter. And the third reason is that one or more the same raising the same issues for the one arbitration. But if you see that ICC case 1998 is issued between Manifestum Ltd and Lux Yachts Company Ltd. And the second, our current case is issued between Lux Yachts Company Ltd and between GSC Trust Me Bank, between the respondent. And there are different parties, not the same parties in the parallel proceedings. And ICC case covers different subjects matters. First case, ICC 1998, is related to damages issue, and our case is related to payment issue under the letter of credit. ICC case number 1998, according to the third part about the raising issues, raises the claims according to Article 21 on page 35 of the case materials that acceptance acts shall be declared as invalid, and the claimant shall reimburse the buyer the damages in amount of $18 million, and the third claim is that we shall pay $7 million of fees. But as we see in our current case, there are claims raising claims only other and regarding to fulfill the payment under the letter of credit. So we consider that these issues are not related, and these parallel proceedings are not related at all and can't be suspended. And claimant respectively requests the tribunal to dismiss the arguments of the respondent and to suspend the arbitration. So there is no reasons for suspending the arbitration.
Okay. Questions?
Well, without prejudice is a very standard part of any contract clause. When trying to construe this clause, can you state in other words what does it mean? Without prejudice?
Without intention to harm or disturb the contract itself.
So in case of any contradictions or problems with construing two very important documents, what document should prevail? I mean, letter of credit versus contract.
Contract is the main contract, and letter of credit is like a guarantee to that contract. So, shipbuilding contracts should prevail.
Should prevail even the letter of credit.
Yeah.
But letter of credit is independent document.
Yes, but as it was said in Article 10, is letter of credit which bank issued by himself. It's shipbuilding contract shall have a full effect on the letter of credit, and letter of credit should not be issued without prejudice to the main contract. So according to this article, we can say that the main contract is the main reference here, and letter of credit should be considered as a guarantee.
But it's independent document, so the value of this document is quite substantial. So can you restate this clause by your own words, as you understand it?
Okay. I understand that letter of credit is independent by itself, but nevertheless, if we see on the matter of case, we have three contracts related. Contract between claimant and the buyer, Mr. Vasyl, contract between the bank and the claimant, and contract between Mr. Vasyl and the bank. And these contracts are related between each other and they became on the same. They are issued on the same transaction on the shipbuilding contract. And our letter of credit comes of the shipbuilding contract itself. It's common sense that it's a guarantee for the shipbuilding contract, and Article 10 proves that the letter of credit is issued without prejudice and the contract shall have a full effect on the letter of credit. And bank issued it by himself, and the bank should be responsible for what he issued, and if
So it's like mortgage to the loan agreement, yes?
yeah.
But it has its own independent character,
But
independent
this
substance, and in any situation, if party comes to the bank and says, well, this is my presentation, the bank has to pay, independently, notwithstanding any possible problems. This is the main important thing in every UCP 600 rules. It's independent and irrevocable.
Yes, but if you see if the current procedure will be in the national courts, but in this arbitration procedure, it will be very complicated for these two cases, and the awards of two cases will be the claimants means that these cases should be in arbitration procedure because they are related. So it's our point is that the LC is related to the main contract.
In practice, two parallel proceedings were initiated, if I'm not mistaken, in Stockholm or in Paris or in London, and they ended up with absolutely different, contradicting each other arbitration awards, which might be enforced according to New York Convention in any state. So two parties, the same parties, arbitration proceedings in different arbitration tribunals, different rules, contradicting arbitration awards, all of them are valid. So no guarantee that the particular arbitration proceedings would end and will not contradict to any court decision or arbitration award rendered by another tribunal. This is the specific of this type of alternative dispute resolution.
Parties agree to the dispute resolution in the application procedure. So even so, we agree to it, and it's the agreement, and we consider that it should be in the application procedure.
Okay, thank you.
Thank you very much. Question from you?
Yes.
No. Okay. Then we have rebuttal.
First of all, we want to make a reference to the sources of law that the claimant took in their proceedings. First of all, we found, for example, in the memorandum provided by the claimants, by the claimant, that there is a reference to the European Union Directive. For example, Council Directive number 98/18 European Council, Directive 2009. So we are arguing that there is no evidence in the case materials that Central and Zapistan are the countries of the European Union. So we don't see the evidence of application of these rules. This is first argument to the source of law. The next, we also saw that there is many cases when, for example, claimant makes the reference to the articles or doctrine, but it isn't proved that it is source of law. We don't see the legal arguments of some argument presented by the claimant. Also, for example,
how would we're supposed to decide this case on the basis of the best practice in international trade, right?
yes.
So how would we ascertain what the best practice is in your opinion?
For example, we understand that first of all, we don't know if Central and Zapistan are the parties to European Convention or European Directive. So it is not proved, and if it will be proved by the parties, by the claimant, it will be accepted for us. And for example, the best practices of trade law, we see some conventions, or for example, some customs of business general, I don't know, or some customs, for example, of normal business practice. But some doctrine or some articles there wasn't relevant evidence that these articles can be applicable for us. Also, for example, at the page 10, you can see the case of...
Page 10 of the record of the memorandum?
Of the memorandum, yes. Page 10, for example, there is a reference to the basic principles of arbitration. We, unfortunately, maybe, don't understand what is the basic principles of arbitration, because there is no other reference, and we don't understand what is the legal basis for this. Also, to the next point that I want to mention, it's that the claimant now states that we are responsible on the letter of credit. Of course, we assume that we are responsible on the letter of credit, but we are responsible to pay to the claimant when it will be duly representing of documents. So now we don't speak about it. I think it will be the part of a substantive part of our proceedings. But we claim that we don't refuse our responsibility on the letter of credit, and that the fact that we don't assume and we don't accept the jurisdiction of arbitrators means that we are not responsible on the letter of credit. Because, for example, the claimant makes the reference that there was a consent in the letter of credit or something like implied consent. We didn't make some agreement, we didn't make some consent, we didn't express some consent to this. And also we need to notice that the claimant makes some reference and some statements that the other case, number 1998, are not on the same parties, are not on the same subject. We need to argue this because, first of all, there is a contrary arguments in the speech of our the claimant to this proceeding. For example, the claimant states that the arbitration clause is applicable for us because we are the party to the shipbuilding contract in this part. But at the same time, the claimant states...
Yeah, half a minute.
Yeah, okay. 1 second.
No, but I think that's a crucial part that you should have mentioned, Article 10. What's your argument on that?
And so we just want to say that, for example, can I finish my first?
Yeah.
Okay. For example, that the claimant said that, okay, you are the party to the shipbuilding contract because you need to take in attention this arbitration clause. At the same time, the claimant states that in other cases there are different parties. Okay, so we are party to this case, but and we are not the party to the other case. But at the same time, we are the party to the shipbuilding contract. It's a contract, and also that.
Okay, I think.
Okay, sorry.
Thank you. Okay.
I will answer. May I answer?
You will answer.
According to one question and according to the second question.
Sure.
Okay, according to the question about the doctrines of the European Union, in the contract, is shipbuilding contract, page 19, point 10. The parties further agreed that the validity and interpretation of the contract and of each article and part thereof shall be governed by the best principles of international trade law. So, we understand best principle, the directive of European Union, such institutions, the directive 98/18 EC and 2009/45 EC as the best principles of international trade law, because it's a very strong institution, and according to this, we understand it's like best principles of trade law.
I will answer the second question about the doctrine and why we use the doctrine, because we think that it's related to our case, and we considered that not only doctrine we used also case law, which were related to our issue and which examined the same problems, and we decided to make an example for it and to make a help for our dear arbiters. And about parties to different contracts and so on and so on. But as I said before in my claim, that there are different subjects of matters of claims, not about different parties of claims, not about contracts or not contracts. So different parties like Vasyl and Manifesto Ltd and Precarpathian company on the claim of Mr. Vasyl, and different parties on our claim, Precarpathian company, and different subjects of matters. So I don't think that it's important I just don't understand the question why the parties are the same about the contract, because we are talking about the ICC cases and its claims, and we should talk about the parties into the claims, about the cases, not about the contracts. And can I now ask questions for?
We won't be asking questions in this format. The rules for the ICC Lex Mercatoria will provide us no questions.
Okay.
Okay.
So you're finished, right?
Right.
Sort of.
Any questions?
Yes. Now, what are sources of international trade law? Let's forget temporarily European documents. In general, what are sources of international trade law? What are principles and what document we can find them, use them, by whom they were approved previously? General question.
Okay, according to the best principles of international trade law, we know such institution as International Chamber of Commerce. It's a very strong institution. Nevertheless, it started like commercial, but because of its strongness and popularity,
Can you name this document?
UCP 600, and then ESP 98.
UCP 600, these are for bankers.
Yes.
If two parties are trading with each other, on international level, they have to use some international agreements, best principles, any kind of soft law which would help them to understand how to solve a particular dispute, how to claim damages, how to participate.
Such principles we can find in unilateral principles and unilateral principles.
What are the UNCITRAL principles? What are those?
Unilateral.
Yeah, but like, what document of UNCITRAL are you referring to?
This is UN Commission which deals with them, but it issues documents from time to time. This document has name and the date of issuance.
Model law for international commercial arbitration.
Okay, that would be a procedural source,
Right.
maybe.
Right.
We're talking about trading. Seller and buyer must have some guidance if they're located in two countries.
Okay, maybe that's something you can hand in after the arbitration in your both hearing briefs. Thank you. Okay, I understand we're now moving over to the substantive part of the argument.
Yeah.
And it will be claimant first.
Yes.
Thank you very much.
So I will be submitting issue number 2, material part. The respondent did not complete his duties under the payment obligations. So the short roadmap of my speech, I have 3 arguments. First is that the act of acceptance was properly signed. Second, the claimant was not obliged to present any ship safety certificate. And third, that the respondent had to fill the obligations in front of the claimant. So, as is stated in the Article 1.3 of NIU Draft Principles of International Commercial Contracts, a contract validly entered into is binding upon the parties. These articles lay down another basic principle of contract law, that of pacta sunt servanda. Since payment clause is the basic clause of the sales contract, it is the obligation of importer to issue a letter of credit complying with the sales contract, and also the precondition of exporter to deliver the goods and to present the documents. So, starting with my first argument, the act of acceptance was properly signed. According to the Article 17.b of UCP 600, a bank shall treat as an original any documents bearing an apparently original signature, mark, stamp, label of the issue of the documents, unless the documents itself indicate that it's not an original. So, as a result of tender dated on the 23rd February 2015, a contract for construction of the yacht was signed. Due to the condition of the contract, the buyer is the Manifestum Ltd, a legal person who is in the possession of Ivan Vasyl, which simultaneously serves its president. So this is, there is a specific authorized body that is responsible for verifying correctness of the signature. The bank checks the signature only by comparison the pages of the contract and the act of acceptance. But he has lack of authority making this. According to the common practice of business turnover, it is accepted that the signature occurs by applying an appropriate combination of the seal and the signature by the authorized person. In our case, such person is Ivan Vasyl. Even if Ivan Vasyl rejects the signature of the act of acceptance, the seal on the act still belongs to the manifestum Ltd. Therefore, it belongs to him since he is the president of the company. Additionally, there is a written statement of John Zagrebelsky, it's exhibit C13 at page 53 of the case, citing, Mr. Schneider was surprised with this request, as on the 24th of February 2016, Mr. Vasyl has signed the acceptance act of the yacht, with broken a bottle of champagne over the body of the yacht, where I and Mr. Schneider were in person. It appears that the only person who could and signed the contract and the act of acceptance was Ivan Vasyl, since he is the only person who had access to the company's seal and has the right to sign the application on it. Thus, the respondent cannot invoke the fact that act of acceptance has no legal force. Our second argument is that the claimant was not obliged to present any ship safety certificate. According to the Article 14.h of UCP 600, if a credit contains a condition without stipulating the document to indicate compliance with the condition, but banks will deem such condition as not stated and will disregard it. Under clause 2.3.1b of the shipbuilding contracts is the exhibit C2, page 15 of the case. The buyer hereby guarantees that $11 million will be paid by the irrevocable letter of credit to be issued by Trust Bank within 14 working days of the date of signing of the present contract. Payment under such letter of credit shall be made upon presentation of the following documents. We have 5 documents without any ship safety certificate. After that, in the Article 10 of the LC, it's Exhibit C, 3, page 22. This letter of credit is issued without prejudice to the shipbuilding contract, which shall have a full effect with regard to the terms of this letter of credit. Thus, as there was no contractual obligation of the claimant to present ship safety certificate in order to obtain payment under LC, bank should disregard such condition and should have effective payment. In accordance to the Article 11 of the Council Directive 98/18 EC of 17 March 1998 on safety rules and standards for passenger ships, all new and existing passenger ships shall be provided with a passenger ship safety certificate.
So you're saying that directive is, as you earlier submitted, part of the best principles of international trade. Are you aware of any other markets where there might be different safety regulations?
About different directives?
Because this is a very specific safety regulation, right?
Yes.
And I'm just wondering whether, and safety regulations are a public law matter, something that the state regulates. And I'm just wondering whether, outside of the European Union there might be different markets which have different standards, and whether we shouldn't take those into account.
Sure, probably every country have its own directive according to the ships. Like why they named what the owners need to do to take this ship safety certificate. And for example, in the URE, they have special, very big document and a lot of statements what they need to do to get such certificate. And it's very big procedure.
And why is that not relevant to us?
It can be also relevant because but we not stated in our case.
Okay. Would it be a different outcome if we apply the UAE?
No, it will be probably the same, but in that document it is bigger procedure, more points. Yeah. So, this certificate shall be issued by the administration of the flag state after an initial survey. According to the Article 10.1 of the mentioned directive states that each new passenger ship shall be subjected by the administration of the flag state to the survey specified below. A survey before the ship is put into service. The similar provision can be found in Article 13 of the Directive 2009/45 EC. Both directives give the definition of the administration of the flag state. under which it means competent authorities of the state whose flag the ship or craft is entitled to flag. In the letter of Manifestum Ltd. To the bank, Mr. Vasyl stated, it's Exhibit C10, page 30 of it is. I failed to find in the documents presented by Lux Yachts any national passenger ship safety certificate for the yacht. Manufactured under the shipbuilding contract, the document issued by the Central Maritime Register, that Queen Ilona is certified for use in Central Directory. So the claimant in any case would be unable to obtain this document, and he was not in the possession of the yacht Queen Ilona at the time, and to get such a certificate, a physical inspection and survey of the yacht needed. So finally, as Mr. Vasyl in fact uses the yacht in Central, it proves that he has already received such certificate from the Central Maritime Register. Fact of yacht using can be counted as its acceptance into the property. According to the Article 60 of the United Nations Conventions on Contracts for the International Sale of Goods 1980,
Would that be something, a source of international trade that parties can look at?
Yes. The buyer's obligation to make delivery is the following ways, either by doing all the acts which could reasonably be expected of him in order to enable the sellers to make delivery, or by taking over the goods. Therefore, the signature on the act of acceptance has a secondary importance, as in the objective reality shows that in fact Mr. Vasyl enjoys the yacht while denying the originality of his signature. Thus, even if the signature does not belong to him, he still took the yacht with his crew at the official ceremony with representatives of the parties. Therefore, agreed to accept the yacht by making conclusive actions what would be considered as the settlement agreement. And our third argument is that the respondent had to fulfill the obligation in front of the claimant. So, as we know, classical letter of credit is based on two main principles. Principle of autonomy or independence and principle of strict accordance. Principle of autonomy follows from Article 4 of UCP 600. Credit by its nature is a separate transaction from the sale or other contract on which it may be based. This principle is confirmed by Article 5 of UCP 600, in accordance to which banks deal with documents and not with goods, services or performance to which the documents may relate. Kliv-Meshmitov cites significant precedent in case Power Curber International Ltd. Versus National Bank of Kuwait. It is vital that every bank that opens the letter of credit fulfill its obligation. The bank is in no way linked to any dispute which may arise between buyer and seller. The buyer may claim that the goods do not meet the condition of the contract. Despite this, the bank must fulfill its obligation. The buyer may declare that it has a counterclaim for a large sum, yet the bank is obliged to fulfill its obligation. It is not allowed any set-off or counterclaim to reduce liability. The second precedent is case Edward Owen Engineer versus Barclays Bank in 1978. It is said that only one circumstance...
Who has decided that case?
Sorry?
Who has decided that case? Is that an arbitral award or is it a
No,
state court?
it's state. Yeah.
Which one?
It's Court of Appeal. It's English President Court of Appeal, 1978.
Thank you.
So, in this case, it is said that the only circumstance that could justify bank failure to fulfill obligations to pay for the credit is when bank clear and obvious that the beneficiary is guilty of fraud. We extend that bank should have real evidence about fraud, but not just notification about it in the letter. So, the respondent issued their irrevocable standby letter of credit by order and for the account of Luxias Ltd. On the 5th of March 2015, Luxias sent the request about transferring money for their bank account with all the exhibits foreseen by the shipbuilding contract. On the 7th March 2016. On the 10th March 2016, Luxias received answer from the respondent. that we are unable to effect payment under the letter of credit. The letter of credit serves as a method of payment, and performing payment of the sum of letter of credit by bank is a normal development of a deal. If the bank refuses payment by letter of credit, such a denial appears as a denial of the autonomous nature of the letter of credit. According to mentioned above, the respondent with his refusal damaged the normal development of the deal. He didn't fulfill the obligation, but backward entered to the dispute which arose between buyer and seller. The respondent